this meeting.
Very good.
For quality and training purposes, Lee.
Oh, yeah, yes, exactly.
You are not my client, and I cannot reveal anything about.
That's right. Right.
So thank you, everyone, for joining today's call. This is our bi-weekly all hands UCLA Health IT project managers meeting. And we have something called the PMO Education Guest Speaker Series, where we invite speakers from outside on topics related to project management and IT. So today we have Lee Weinberg for us joining us today to talk about the topic that we chose is the do's and don'ts of contract negotiations. As project managers, you may not be directly involved in such negotiations, but you might be the recipients of such negotiations, and it's good to know what happens on that side. So this is from your PMBOK or PM knowledge area. It's in the procurement management area. So Lee Weinberg is a managing partner at the 28th Lawyer, Weinberg, Konzer, and Frost firm. And he's consulted many individual and corporate clients in connections with specifically business divorces, partnership disputes, and investor operations. And his work includes financing transactions and financing and intellectual property and the litigation that comes with it. And his main industry concentrations are hospitality, media, aerospace, and technology. And here's a good story with the Umami Burger, so you'll maybe talk a little bit about it. And he's been published and quoted in various magazines and journals, esteemed magazines and journals like Bloomberg and others. Just minimize all this stuff. And he's also attended some panels at the UCLA Anderson School of Business. And he has a law degree from Yale and BA from University of Manchester. And with that, I'll turn it over to Ian to moderate this. We're going to do like the usual fireside chat questions. You can pose your questions on the chat or interrupt and raise your hand and verbally ask the questions. So with that, I'll turn it over to Ian.
Thank you so much, Sankar. And folks, before we begin, if your background allows, it'd be great to see your lovely faces. So Lee will know that it's not just a chat bot behind the little squares. So that'll be great. Well, Lee, again, thank you so much for joining us again. We're super lucky we had Lee join our faculty practice group cohort for the PMP bootcamp a few months ago, and the feedback was really good, very educational. So Lee, thank you for coming back again. And for today, before we jump into the topic of contracts and NDAs and all the fun stuff that comes with procurement management, love to go through a little bit about your professional journey, Lee, just where you started and how you ended up here.
I'll try to keep it short.
Sure.
In a long, unfortunately long career.
It's a good thing. It's a good thing.
I'm never going to retire. I started off at big New York law firms to keep it short, and did my duty for 9 years with big law, and learned a lot, especially my first few years. They had us walk the plank. They had young lawyers out there just doing things that more senior lawyers should be doing. And it was a great experience, but I left the law to be more of an entrepreneur. And among my entrepreneurial things was a .com, just like everyone else in 1999, ran a .com, had a reasonably successful exit. That was it was an intermediary that showed you what's on sale in real stores, so to keep it short. And we were out about 7 years too early in mobile. And then I left that to restructure an aerospace engineering firm that's still running. If you want to take a peek, at the very techie cover, of the web page, it's aeng.com. aeng.com, and that's AEI Systems. And the reason I'm mentioning that is I'm going to talk a little bit more about contracts in the world of government and government affiliated entities. Try to keep it short if that doesn't interest everybody, but the customer base for that company is Lockheed and Boeing and Raytheon and ultimately the government, NASA, and a lot of the parts of the NSA, frankly, parts of the government that don't want to be in the newspaper. So that's an interesting aside. But then I went back I still have a part of that business, and it's been operating for 25 years now. But I went back and became a lawyer again because I do love being a lawyer. And I'm mostly a transactional attorney. And I draft contracts all the time. In fact, I was working on one just before we got on this call. So that's the journey. I've got 28 lawyers I'm working with at my firm. So that's an entrepreneurial endeavor of itself, dealing with that many lawyers in one place. And that's the story. Hopefully that wasn't too lengthy.
Not at all, Lee. And so diving into contract negotiations, you mentioned while we were chatting, waiting for folks to hop on, that there's more don'ts that we need to be mindful of than the do's. Love to hear a little bit more about that.
Okay, well, some of the don'ts are making assumptions that when you've drafted something that the meaning will come through to someone who's not written or read the contract before. So as complicated as legal language can be, you want to make sure it's precise. Sometimes people go, that's too much legalese for me. The reason there are long sentences in legal is you say A, provided, however, B, except for C. And everyone, their eyes glaze over. But the reality is that my job and the job of the legal people around you is to draft something that cannot possibly be misunderstood. So if you think of it that way, that's why all the ands and ifs and but whatevers and exceptions are all so important, because when you end up having an argument over a contract, when two parties have a fight, and they could say, well, it really means this. And the other side, no, that's not what we meant. We meant this. And the more precise the language can be, the less someone can make a crazy argument that you really meant A when you actually meant B. And so that's the first thought I have for people that are not lawyers is try to be tolerant of the legal language and understand that your lawyers are drafting to be as precise as they can. They're not trying to impress you with how smart they are. So,
sometimes they do.
there's a few lawyers out there that try to mark everything, no matter how simple it is. But that's sort of a big picture issue for people that are non-lawyers looking at legal documents. And they're like, why is this 18 pages long? And so that's the big picture one.
Okay,
in terms of
I have a question right off the bat to get us going then.
Sure, go for it.
So in a lot of our contracts that we do at UCLA, we go through a lot of contract discussions about what our relationship is going to look like. But some of our vendors then have user agreements embedded in the software. So when you sign on, there's a separate agreement. Which one wins if you are having that discussion and they contradict?
Typically, the click-through agreement can be found binding, and usually it depends on what your other agreement says. I mean, if the agreement that the one you did last is usually governing, assuming that they have something called an integration clause in them. The integration clause being, this is the only contract. There can be no amendments to the agreement unless we both sign something new. That's an integration clause. There are a lot of times people don't have an integration clause, which means, frankly, right after they sign or do something, they can have another oral conversation 2 weeks later that completely eviscerates the agreement they thought they had.
Yeah.
So you want an integration clause. So that's actually one of the do's. You have to have it. But your question is, if you think, now, did you have a written agreement first and then have a click through? I want to make sure I understand the question.
So what I've seen happen is that we have negotiate in good faith with the vendor. We reach an agreement, we install the software, and then the software itself has a separate kind of embedded agreement that we would get kind of after our negotiations, but they sometimes conflict. And not always do we take the time to compare and contrast and see which ones where the terms and conditions might differ from what we negotiated.
Well, there's two ways to defeat that come to mind immediately. One is have an integration clause in the agreement you agree before you get the software that says one of two things. That, well, pretty much says this is the agreement, and unless we sign, S-I-G-N, and not in case we agree again or in case we write again, use the word to sign again. So unless we sign a new agreement, this is the agreement. That way a click-through is not the same thing as signing something. And so you're going to be able to have your document governed. So that's a thought. The other is to actually be very express in your agreement that says no click-throughs count. No embedded agreements in the software will apply.
I like that one.
Yeah.
Put a big
Now,
effort.
then you'll still be in a fight a little bit.
Yeah.
On both sides, but you won't lose per se. But if you have an integration clause or you don't say that, their click-through might actually win. And so you want to be very careful there.
Great advice. Thank you.
Sure.
That'd be 550, Mike.
I won't tell you the hourly rate.
I'm calling Kate now. So
That's right.
Special discounts for Ian.
That's right.
So that's sort of a big, one of the very specific things is do have an integration clause. If you really intend your contract to be final and it's not a moving target. If you do want to put together a sort of a term sheet for discussion purposes, but don't want to get trapped into having an agreement, make sure you put something right in that term sheet. It says, by the way, this is just for discussion purposes. Nothing here is binding on anyone unless we sign, use that word SIGN, sign definitive agreements. So that way you can trade back and forth emails and say, but this is just for discussion. This is not the agreement. Because if you suddenly get cut off and someone takes action based on your email, they can claim that they acted because of an agreement you made with them, and they can have an enforceable right against you. So being loose with the emails that sound like agreements, you got to be careful there too. So always call it proposal or a plan or a term sheet that's a non-binding term sheet or something like that. If you're getting down into any details at all, if you're down to making bullet points, be careful you don't make an agreement without meaning to. And that can include conversations on the phone, believe it or not. Especially if someone takes contemporaneous notes, they can show a court, hey, I took notes of this call. It took place on this time. It was with Ian. He said these things. I said these things, and we made an agreement. So go ahead.
For an example like that, Lee, does it only become binding if I then share that with the group, like kind of like you share minutes and like, hey guys, here's my notes, or how does that work?
Well, if you have what's called a parent authority, meaning you're vice president of whatever company or organization, that would imply you have the right to make contracts to the person on the other side, or the court will say you were called vice president. That unless I hear otherwise, I'm able to assume that you have the power to make an agreement with me and you don't have to show it to anyone. That's one risk. There's a way to guarantee, if you're on the flip side of something and you want to guarantee that it's an enforceable contract, if you get two signatories of people on the other side of a company, guaranteed enforceable. that's a California rule. I can't speak about all the other states. But if there was a question whether or not Ian can make a deal with me, if Ian and Mr. X or Mrs. X gets on with me and they said vice president next to their name too, and they both sign, I could go into court with that. And it's enforceable for sure. Whether or not the company gave any authority to Ian or Mrs. X at all.
Oh,
So
wow.
these are the sort of things that if you're on the other side and you're worried you're dealing with someone that doesn't have authority, you can try to get a second signature of another officer on the same document, and then you feel really good. Whether or not you saw officers' minutes or their empowerment and their bylaws or et cetera.
Signature. Nice. I
A
had
lot of tricks of the trade when it comes to forming agreements. I want to make it clear so that people understand that they don't make an agreement when they don't want to. If you meet someone and you shake hands with someone, that can be an agreement.
Mhm.
If you say, let's partner, and you shake hands with someone, that's assumed to be a 50-50 partnership right there. It's amazing how easy it is to be found under contract, under an enforceable contract. And so that's actually the do and the don't is don't form a contract unless you really mean to. So that all that background about doing proposal and this is not enforceable until we all sign and that sort of stuff is to protect you against someone making claims that you made a contract with them.
Nice. That makes sense. One of the things that always intrigued me, Lee, for lawyers of your caliber is that whole contract negotiations that you see in the movies and in series, and you know, like you've represented folks like Larry Ellison, Elon, the biggest cats out there. When you're doing these big negotiations, do you have any pre-game? Like, is there anything that you do, any rituals, any prep? Like, I know Obama listens to Eminem before he debates. Do you do anything like that?
No, I don't play a musical instrument or run or do jumping jacks or anything. What I do though is I try to prepare for the call and making sure, because in all of our businesses, we're especially the world today with the number of emails and texts and phone calls and other matters. So all of us operate as multitaskers, even if we don't want to. And so I go back and spend 10 minutes reviewing where I'm at, to be frank. And that sounds really basic. And it seems like, God, your memory must be terrible, but that's not how it is when it comes to contracts and agreements. They're so detailed that you want to go back and look at your notes and figure out where you left off last. Make sure you have the newest copy on top on your computer screen or the newest markup on your computer screen, and have a mental game plan of how you want to go about this negotiation. And the other thing is, make sure that you're not going to make an agreement that you can't back out of, even if you had no authority to make it. Now, the lawyers suffer from this more often than the principals. The lawyers say, yeah, I agree, except in reality, I need to go check with my client. So if you can figure out in advance what the client will agree to, you'll have more power to get the deal done. If you're not sure, you'll have to say, I will take that back to my client, a fair amount. So those are the sort of things I try to do in preparation for a big meeting, is to talk to my principal that I'm going to be negotiating for and say, what are your hot spots and what will and won't you agree to as I go into this? So at least I'll have some major points that I know I can negotiate, as opposed to saying every time someone says something, I'll say, sounds great, let me get back to you.
Let me get back, yeah.
Then it feels like there's nothing getting accomplished. So it is important to look at where you are and the power you have to make decisions. If you have to involve other people on the call. Another thing I do that I think is related is what happens when you've got it down to 8 points. You've got a 50-page document or a 100-page document. You got it down to 5 or 8 points. You can't seem to get over the hurdles back and forth, even with talking to your principal, they talk to theirs, and the lawyers are doing this. See if you can get everyone in the room at the same time. It's a real good practice. If you can do it, even if it's a conference call with everybody on the phone, that's second choice. But if you can get people in the room, we're all human beings, and human beings, in my experience, are much more likely to compromise and come to agreements when they're acting like human beings in the same room. When it's you're hiding behind your lawyer and you go, no, 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 go get this and that, and you can, and then you don't have to deal with the interactions with the other side. You can make decisions that are not easy to achieve. And you end up, so when it gets boiled down to several points, I recommend it's an all hands. If you can't get through them. So that's sort of a do in contract negotiations. Try to get it all done if you can. But if you get it down to only a few points, see what you can do about an all hands to get over the finish line.
I remember in our previous session, you talked about how sometimes you need to negotiate with your principal and reason with them so that you can go back and reason with the other side. What are the things or tips, tricks, or things that you've done in the past when emotions get high and you know stakes are high and people are not being reasonable? Do you take a 5? Like, what are the things that you do, especially with the cases that you take on? These are not small peanuts.
Well, first of all, I should say that no matter how small the project is, it's never a small matter to the client. Whoever the client is, it's hot. It's very important. So I go about it the same way. For the most part. There are exceptions where I know the personality. You need to know the personality of the person you're speaking to. Do they need a day off before you call them? Maybe they need to ruminate. So there's 2 or 3 approaches, and you have to decide which one's the best approach to the person you're dealing with, the people you're dealing with. First of all, does your client have partners and they don't even agree what they want yet? So if you're dealing with one person and you know they're making the decisions and that's it, you've already eliminated one of the possible issues. But it's easily, there could be a committee you're dealing with or 2 people you're dealing with, and you want to make sure that they're aligned. You may even try to get them on the phone at the same time. They may not even realize that they're not aligned on some stuff or the details of those things. So if your client is multiple people and you can possibly get them on the phone at the same time to go through the issues, I think that's helpful. Also, as you know, maybe I'm speaking as the lawyer, I don't want to get fired, which happens sometimes when you give people the news they don't want to hear. But if you can have the multiple people on the decision makers on at the same time, they may clarify it and argue it out for you. So let's suppose you're the project manager, but there's 2 vice presidents above you and they're both involved. You don't want to tell them, hey, you have to do it this way or we're going to fail. If you're trying to avoid that, even if that's the truth, if you have those 2 people, they may argue it out themselves and you won't be the person that's sort of put under this ridiculous amount of pressure to get something done when they haven't really given you good instructions.
It makes sense.
That's a thought. Now, assuming you have just one person really making the decisions, how do you give them an analysis? I try to bullet point it. First, there's 2 ways. I mean, if you know the person can do it over the phone, do it over the phone, for sure. If you know that they're not able to concentrate on the phone and or will react spontaneously in a bad manner, I'd put together a very short bullet point list of the open points. Say, here's their position, here's our position, let's discuss. And then have them think it through a little bit. And then they can come to or you could say, could you compromise this way? As opposed to, you really ought to compromise this way. People, different personalities, right? You need to know who you're dealing with. So I hate to give you such a mushy answer.
No, it makes
but
sense.
It's really about human beings to a large degree, how you approach that.
Lee, you mentioned you wanted to share something on screen, the do's and don'ts, or something you had. Do you still want to share something?
Actually, I'm not going to put the do's and don'ts up on the screen. I think if we have some time, I wanted to go through some NDAs
Okay.
Sure.
and which is the contract that people see a lot, and just sort of give people a sense of what's in there and what should or might be in there that might be a little tricky, and to understand what's going on. But if
That
you
would be
want,
helpful.
does that mean you want to step ahead and away from the do's and don'ts concept, or what?
Let's finish the do's and don'ts and then switch over.
Oh, okay.
Yeah, we still have 20 minutes. So
Oh, sure. Okay. So in terms of do's and don'ts, I gave you the sense of understanding the complexity and why it's there. I think you also want to be very clear who the parties are that are making the agreement. And that may seem strange, but there are companies that have affiliates, subsidiaries. You're trying to actually nail down the behavior of a certain human being, and they use a company, and you say, well, we actually still need the human being. You need to think about exactly who you're trying to nail down into this agreement, and whether or not the agreement will actually be enforceable against that person. Just because you kind of think that that person's on the hook, they may not be. So you have to be very clear in your contracts in that regard. That's just something to think about, especially if you're dealing with services. For example, a service provider may say, well, I may be a solo or with a very small company, but I want to use my corporation as the contract party. And you should say, that's great, but we're going to also have a part of the contract where you agree to provide your services personally. Otherwise, you could go lay this work off on anybody, right? You're a corporation. You could say, well, I decided I'm going on vacation and Ian's going to do all the work for me. Meet Ian, he's really great. And if you were hoping to hire Bob, and Bob's the person you really want, then you're in trouble, possibly. So that's an example of a do and a don't. Make sure who the parties really are and that you're getting the product or services that you expect. Another thing to concentrate on that a lot of people misjudge is what law will apply. And what courts will the law be applied in, or will there be arbitration as an alternative to a courtroom? These are what I call the stuff at the end. As a sort of a funny saying, and even lawyers make this mistake. They get all the meat of the contract done, the important parts, the business deal, and then they kind of go, well, about 8 paragraphs at the end. Let's just get this thing signed. And that's what I call the stuff at the end. And that stuff at the end, every bit of it's important. There's a reason it's there. It's giving someone an advantage, or it's clarifying something. Frequently, for example, if you are the party receiving money from someone and they have the money and you're waiting to get paid, you don't want to let the court be in their location. You want the court in your location, because if you need to sue, who's going to need to sue in this relationship? It's the one that didn't get paid, most likely. So you want the court to be your city. And that's a really good reason it should be in your city. So you're not having to sue in Istanbul to collect your money against the company from Turkey, or even in New York if you're in Los Angeles. Do you really want to hire New York lawyers, travel to New York if you end up in trial? The expense and time and energy are vastly increased. And conversely, if the party on the other side's not in your locality, you're putting more expense on them to come to your town. So, and it makes it more likely you'll get where you want to go. So think about where the court's going to be and what law is going to apply. It can be a big deal when things go south. And that's the thing to remember about contract do's and don'ts is, yes, we all hope to put the contract in a box and never read it, and we go on forever. There are 2 reasons to think hard about having a really good, solid contract. One is people forget what they agreed. And this is really common, even amongst the people that love each other and have no real problem with each other. But suddenly it's like, wait a minute, weren't you supposed to pay me within X period of time? Or how much money were you supposed to pay me? And then it was deferred. And how long was that? And this, and then they forget because a year's gone by and they honestly don't remember. And suddenly they're like, now you have a piece of paper you both can go to and you say, this is what we agreed. And it's very clear. So why do you really want that contract? The second reason, in addition to keeping the peace between parties, is that if things go south, that's your document. That's the reason, that's the thing you can rely on to enforce. Absent a written contract, there's oral agreements, there's things people did in reliance called detrimental reliance. There's all kinds of arguments you can make, but you're going down a long pathway to prove the agreement. Whereas if you have a well-documented agreement. So the stuff at the end is, one of the stuff at the end is the thing we talked about earlier, which is the integration clause. You'd be amazed how many people try to lawyer stuff by themselves and they leave out an integration clause and it's a disaster. People can say whatever they want. We walked in the park and we made a different agreement the next day. And suddenly you have nothing.
That sounds like a title of a good book for you, Lee. The stuff at the end.
It's happened. The stuff at the end, actually, I mean to write an article titled The Stuff at the
Oh,
End.
there you go. Yeah. It's things that people, especially if it's boilerplate templates, people just disregard that, if you go into trial, you have to go to Arkansas. There's like, it's part of the boilerplate. No one really pays attention, things like that. And if, you need to, now you're ending up in a, Motel 6 in Arkansas. So
Yeah. Stuff at the end is stuff like if someone waives their rights at one occasion, it doesn't mean they waive it the next time you make the same move. All different little details that come up. All that stuff matters. So waivers, there's no, duties. This party does not have a duty to the other party to do something. It's only whenever they feel like doing it. There's a lot of stuff at the end. So don't ignore the stuff at the end. I mean, that's the short strokes. Recognize that every word in that contract is powerful in one way or another.
We do have a question. We do have a
Go ahead.
question. It's just interrupt. We do have a question on the chat.
Yes.
This is more not directly related to this question that we are discussing, but without naming names, can you describe the most interesting legal issue you have dealt with?
Wow, the most interesting. There's a lot. So maybe I'll pick one or two.
without mentioning
right away.
Elon, which one did, no kidding.
Well, the most interesting legal issue I've dealt with. There's been so many disputes over so many different provisions, it's hard to pick one. I think the lack of an integration clause, though, and that's why I mentioned it so many times, the lack of an integration clause creates a host of possibilities that you have to fight for or against, because you don't have a written agreement that everyone says is the final agreement. So the things that become interesting is suddenly you have to have depositions or interviews of people under oath to tell you what really happened. And you can have some people lie, to be frank. There are people that tell lies, and there's not a lot you can do about it. So interesting stuff is more situations than issues. We've had to hire PI, private investigators, to go out and knock on people's doors and uncover. You have to even find out where they live in order to serve them the documents in the first place. You have to, we've brought in husbands and wives for depositions that normally we would not, because it creates, first of all, to actually get real information on the behaviors of their spouse. And second, because it creates pressure, frankly, on the other side, because who wants their spouse getting deposed? So these are sort of issues and situations that come up all the time once things go south. In terms of interesting before they go south, it's the negotiations and who ultimately makes the real decisions at the end of the day. You can go way down the path, and then suddenly someone jumps up and cancels the deal. I don't know if that's interesting as much as devastating, but that can happen. I'd say all the things that end up in litigation become very interesting.
But just a follow-up to that, how important is, I think it's BATNA, where you are when you're negotiating, BATNA.
Having an alternative, being willing to walk away is how I translate that. Would you agree with that?
Vivek?
But I just want to make sure that, would you agree that, yes, right, best alternative negotiation. I call that your walk away. Your statement to the other side is if you know, I either I have it in my mind, in my background, in my head, I can go do this other thing, or I state it directly to the person I'm negotiating with, saying, if I can't get this, I've got this other alternative. Are they important? Absolutely. In fact, right before I got on this, conference, I was telling a client, we worked up a term sheet we're going to present to the other side. And I said, you know, we're taking strong positions. We're cutting in half what they want to get. I said, is this your sort of your best where you want to go, or you can go a little higher? But at the end of the day, if this person comes back and wants what they want, are you willing to walk away?
Mm-hmm.
Came up just before this phone call. I asked the client exactly that. Are you willing to walk away? And that is the same issue in a way. It's not BATNA per se, but it's the same idea. Your alternatives are better from your perspective than to make the agreement that the other party's trying to get.
All right, next question. What's the balance between moving a project forward versus holding a project when there's a contracting issue?
That comes up a lot. Frankly, when there's real urgency on both sides, we get compromise. The things that hold projects up isn't usually the lawyer, although there are lawyers who are very slow. It does happen, or lawyers that are just in a big organization, lawyers, you can't get their attention because they have too many things on their plate. But when things are in a hurry from both sides, you get what's called compromise. And I think you won't have really got a real delay. I think the delays come when both sides, or one or both sides, just can't get there. And so what's the balance? I mean, as a lawyer, I try to move it ahead, obviously, and I try to talk to my client and say, look, you know, this request seems like something you can give. Maybe you can't give this. Let's narrow the points down as much as possible. But my experience is when the other party really wants the deal, it moves faster. It may seem very obvious. I hope that answers the question without being flipped.
Okay, thank you. We have 8 minutes left, so maybe we can talk a little bit about the NDA.
Oh, yes. Okay. Let me share my screen and walk you through an NDA and a couple of circled provisions I've got. Let's see. Is this it? Which screen do I want? Here we go. Okay. Going up to the top. Non-disclosure and non-use agreement. The reason I'm highlighting this, most of the time people call it an NDA, a non-disclosure agreement.
Can everyone see what
No,
Lee
we
is
don't see
sharing?
anything.
Oh, you can't see anything?
Not yet. Just
Do you see nothing?
hit share screen.
Oh, I didn't hit.
Sure.
Sorry.
That's
How
all right.
silly. How
No
silly of me. I didn't hit the share button.
Yeah, now we can see.
Now
Okay.
you can see.
Yeah.
So if you look at the top, this is a contract that is being very explicit about something. And even I don't do this all the time. But when you do an NDA, a non-disclosure agreement, is there or is there not a non-use provision in it? And this is a clear mistake a lot of people make. And if someone's very sharp on the other side, I like to think I'm one of those people. I manipulate this one way or the other. For example, someone says, hey, Ian, we're going to sign an NDA and you're obligated to keep all of my information secret. You say, no problem. But then Ian says, I said I'd keep it secret, but I didn't say I wouldn't use it. Ooh, there you go. You've now allowed the party on the other side to use all the information you give them to create a competitive company. If you don't have a non-use provision.
Lee, I know that Tesla former employees are in some sort of legal hot water after moving to Rivian and using some of that technology. I wonder if this is one of those instances where it was a non-disclosure, but maybe not a non-use.
I would suspect at Tesla, they haven't made that mistake with employee agreements. The time I see this come up is usually between companies where they're not thinking about the exact issue, and it hasn't come up about the other party taking and using it in their minds, and they kind of miss the issue. So there are times, and I'll be very upfront, there are times my client, I go to them and I go, look, you all are going to share information. Both parties are going to share information. Are you more likely to want to use their information, or are they more likely to want to use your information? And if the other party's like, I want a short form, and we'll say, yeah, you know, we'll send them a document that doesn't have a non-use provision in it and have the ability to use whatever they send us if necessary. So it does happen. Typically, my forms do not do that. I try to draft mutually and very tight when it comes to NDAs. I assume both parties are very careful and very cautious about anybody having and or using their information. So my typical form has it. The reason I put this one on the screen is actually put it right in the title, which almost never do. But I said, I want everybody to see that. We're talking about non-use. Make sure you understand. So that's sort of the lesson here. Let me walk through this quickly. This is basically identifying who if it's mutual, you identify, this one is not mutual, I'm sorry. This one is, there's a disclosing party. You may note the name of the company I mentioned earlier. That's, you can find their website. And then the other side. So this is a one-way NDA. It's not a mutual NDA. So again, think hard. If I have a one-way NDA and the other side starts telling me information, I'm not under NDA. So you've got to think, do you need mutual or not? There's usually a list of exceptions to what is confidential. And I'm not going to go bore you through the list, but basically, if you got the information from the public, or you got it from a third party, or the government requires you to disclose it, it may not be confidential anymore. This is definitions of trade secrets. I'm moving really quickly through this because I've got other stuff to show you. Term of the agreement is, this is very tricky. You'll see an NDA and it says the term of the agreement is X number of years. That means the term during which you disclose information to each other. But what you want to be sure is how long will the information stay confidential or non-usable. If you want to be tight, put it at 10 years or more, or survives forever because it's a secret. Coca-Cola's recipe is still a secret 150 years later.
Wow.
So when people go, well, I only want to sign a 3-year NDA, you're like, well, wait a minute, in year 4, that means everything I told you, you can go create a competitor? That doesn't seem fair. But big companies do that to little people. So be aware.
Just doing a time check. We have 3 minutes.
Oh, we're down to 3. So let me try to show you another one. I'm moving quick. I'm going to skip a couple of these. What you use for the purpose of the information. So if you have a non-use provision, you can narrow it, say you can use it, but only for X. Very narrow. In this case, evaluating and advancing the specific relationship we have with each other. So, and here's where it says the confidential information shall be of unlimited duration, shall remain confidential indefinitely. Well, I'm moving more quickly because I want to show you the other stuff. Very specifically, you won't reverse engineer. There's one. This is the Nevada comfort. Here's the one of my favorites, Lockheed Martin. Okay, we are going to have an exception. Suddenly Lockheed says, I have a mutual agreement with you, but guess what? Except I can do whatever I want as long as it's internal to me. And they stuck it in the middle of a mutual NDA. You have to read these things. that's sort of the lesson of the day. These NDAs are real contracts. I call them the Rodney Dangerfield of contracts. They get no respect. People sign them willy-nilly and they get in trouble. So that's sort of there's more to go, but that's the end of the lecture on NDAs, given we don't have a lot more time.
Thank you, Lee. Ian, do you want to close it out?
Maybe we can take one more question if folks have a question before we go. All right, Lee, thank you so much for your time. We can spend hours going through this. I really appreciate you taking time teaching us about these things. Because again, we all want to get projects going, and sometimes you rush through the contracting bit or just kind of push, and not knowing that the things at the end might actually bite us. So thank you for that reminder and these really helpful tips that you've shared with us today.
All
Thank
right.
you,
Thank you so much.
everyone.
Thank
Thank
you.
you so much, Lee. Appreciate
you.
you.
Good to be here.
Bye-bye.
Bye-bye.
Okay, guys.